Hi everyone, my name is Tuan and today I will talk about the Minors Act 1970 in New South Wales. There seems to be considerable debate over whether it is desirable to reduce the age at which a child can fully be bound by contract and deal with property. The common law has set the age of majority at 21 over many years. The Minors Property and Contracts Act of 1970 in New South Wales defined the age of maximum ability in contract and property matters as 18 years. The legislation, on the other hand, goes far beyond just reducing the age of majority. Attempting to create a system that safeguards those who are also under the age of 18 from the consequences of their own inexperience and lack of judgment, but still ensuring that adults dealing with the minors are not prejudiced. Infants' contractual capacity was very limited under common law, and could not be expanded, as in many legal systems, by a parent's or guardian's consent either in general or for a specific transaction. It was accepted that a contract should not be imposed against a child unless it was favorable to him in the sense that the contract was equitable and rational in its entirety. As a result, the effect of any unequal clauses of an apprenticeship or work contract on a child may be found to be so extreme that a contract that was otherwise equitable was made unenforceable against him. It is said that it is detrimental to those who work with children, and disadvantageous to the infants themselves because it discourages those from working with them. The Minors Property and Contracts Act 1970 adopted the New South Wales Commission's recommendations on substantive reforms to the legislation pertaining to minors' contracts and property transactions. The provisions act as a code, see Section 17, and replace the common law. Aside from seeking to clarify the legislation in general, the provision states that all favorable arrangements are binding on minors. The Act lowers the age of majority to 18 years and does not affect the legislation relating to a person's capacity to be bound by his acts if he is too young to comprehend them. But it does restrict all other aspects of a minor's property rights in general. Another significant reform in New South Wales is that the court now has the authority to allow a minor to enter binding contracts and make binding property dispositions under Section 26. Certain other officials are also granted limited authority in this regard, Section 28 and 29. In the case of a minor's contract repudiation, the court is also granted broad powers to change rights and liabilities in Section 37. The common law provides that a child's inability to recognize because of his or her tender years makes him or her incapable of voluntarily disposing of property or accepting a contract which is protected by Section 18. The Act's goal is to change the conventional protections for minors and turn the balance towards the interests of the adult engaging with a minor. The fundamental idea is to tie a minor to legal actions that would benefit him. When a minor rejects a non-binding civil act, the court is granted broad powers to amend property rights and award compensation. There is an example for the Act is a case law of application by John Gerard Klumper and Maxine Louise Klumper, 2003, New South Wales SC 854. The case's final verdict is that minors' property can be leased and the application to vest real estate in minors in trustees has been postponed. Mr. Klumper has a 4-year-old and a 7-year-old. He has also arranged for his children to become licensed owners of 2 strata title lots. The property was transferred to the children without consideration or any consideration of how the property should be handled for the children's benefit. One of the properties was developed into a restaurant. The restaurant has previously been run by a business controlled by Mr. and Mrs. Klumper, according to an agreement that seems to have been carried out within the family. They have decided that leasing the restaurant would be better. A tenant with years of experience in the property business has been found for that property. One of the orders sought in this case is that Mr. Klumper is assigned to perform the lease under Section 50 of the Minor Property and Contracts Act 1970. In Tickle 1987 case, Young J said the only restriction on the power under Section 50 is that there must be vested in the minor the beneficial interest in the property. either at law or in equity, and it must appear to the court that the disposition, etc., is for the benefit of the minors involved. The evidence, in this case, does not go into great detail on how the lease conditions favor the children. The provisions of Section Minors Property and Contracts Act 1970 would appear to give the court the authority to order a disposition of minors' property that resulted in the property being vested in trustees for the minors, but whether the power was exercised would depend on the evidence.